This conference will now be recorded.
Meeting for our November meeting already. Can you take the roll, please?
Commissioner Cleo?
Here.
Commissioner Bessler?
Here.
Commissioner Cassidy?
Here.
Vice Mayor Cos?
Here.
And Mayor Pugh.
Here. And let's stand for the Pledge of Allegiance. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. All right, everyone. You have the agenda before you, and are there any additions, deletions, or modifications to the agenda?
I'm just going to make a quick announcement at the end of announcements.
The end of announcements?
Yep.
So we'll do that as F.
You resigning too?
No. No.
Anything else? All right. President, we want to do approval agenda?
So moved.
Second.
Moving on a second. Any other discussion? Hearing none. All those in favor signify by saying aye.
Aye.
Aye, motion carries. All right, presentations and proclamations. Chief, you're up.
I'd just like to introduce Shay. She's a brand new dispatcher to our agency. Her first day was today. We have another dispatcher in the background process. Hired full staff with dispatchers. Thank you, Shay.
Thank you.
Everybody knows Officer Dab, our community police officer. Well, we have a new addition to the police department. His name is Dash. This is our canine dog. We've gone from canine dogs that sniff out drugs and bombs and bite people to hugs. Dash is there for a number of reasons. Mentally ill, violence of victims of violence, kids, the sick, our elderly population. He's already made 2 visits to the hospital for residents that live in town. And he's going to be on patrol now. He's Deb most days. And he just graduated from the Paws and Stripes program the sheriff's office put on. We actually have a video of Dash's graduation. That's the sheriff there. So he is certified. So that's it. But if you see Dash on patrol, you'll know why.
Thank you.
Thank you.
Thank you, Chief, and welcome back. All right. Let's go ahead and move on to the announcements.
No, I've got Ron Kern's presentation.
Oh, you were on your announcements. Okay, go ahead.
Okay, so Ron Kern couldn't be here this evening, unfortunately, and he asked me to make this presentation for him. And we do have several Crown Colony residents here, so if there are any questions, I know Paul's prepared to answer. Putting my Ron hat on. Tonight I'm presenting as the president of the Colonial Crown Manor Disposal Systems, the wastewater treatment plant that services Crown Colony, Colonial Ridge, and Ocean Manor. A failure at the plant exposed a larger issue that will eventually affect the majority of the multifamily homes in the town, especially those with injection wells. A brief background, the plant is licensed and highly regulated by the Florida DEP. The plant uses deep injection wells as the clean water outfall. What the deep injection wells do is they treat the sewage, and then the effluent, which is the water that's been treated, is pumped down to the ground, typically like 2,000 to 3,000 feet, so well below the water table. The plant has redundancies in every phase of the treatment process. They have 2 injection wells there to treat the 3 communities. One of the 2 injection wells has had a catastrophic failure. This happened over a year ago. It is not recoverable after months of geotechnical testing and expert engineering diagnosis from JLA Geosciences, Inc. and U.S. Water, as well as input from the Florida DEP. The conclusion was to drill a new well. The DEP permitting process for the new well is why I asked to speak tonight. One would think that the DEP would evaluate, and knowing the situation would allow us to apply, engineer, and install a new injection well. They haven't yet, after over 1 year of back and forth conversation. The outstanding question pertains to the interpretation of Florida Statute 403.086, sewage disposal facilities. These are the regulations required for constructing a new treatment plant. Some of the requirements of that statute are that you have to have a secondary waste treatment and a power outage contingency plan, among other things. Is a new plant regulation going to require that there be advanced waste treatment as a condition to install another injection well? Based upon the conversations to date, there are 3 methods to meet parts of this regulation. One is that if it is not a new plant, then business as usual. Another is HLD, high-level disinfection. That's basically filtration and higher threshold for fecal coliform. Or is it AWT, advanced waste treatment? This involves a process change that would allow for nutrient removal. There are different standards and different costs associated with each. To upgrade this plant to AWT is estimated at $1.5 million. The DEP was no help in determining a solution. We decided to submit the application for the well permit with 97 pages of technical data, environmental impact, and engineering specifications, as well as the process for abandoning the old well. A total of 13 permits are required for all of these processes. We have spent $70,000 on consultants and engineering to date. The money, though, is not the issue. A paragraph from me to the DEP included in the permit application stated the urgency of issuing this permit. It pointed out that with only one operating well, the risk of failure of this will be a major crisis. This is something I think about every day and night. If a failure did occur, we would need to abandon the 3 communities, all 290 units, making $100 million worth of property unusable. Worst of all, we would make 120 to 135 full-time Ocean Ridge residents homeless. We have looked at alternatives to avoid this catastrophe. For example, bringing in tanker trucks, but at 60,000 gallons a day, it would require 12 trucks a day at a cost of $180,000 a month. We could also pump directly into the intercoastal waterway. No. The optics of this and the DEP would never let it happen. The plea to the DEP went unanswered. The current thinking is that we may receive a permit for the well. However, the licensing will need to be reviewed the next time the plant is up for renewal in 2.5 years. We may get by this one without further requirements from the DEP. The next renewal is 5 years after that. We will not be issued a new license without an upgraded plant to AWT, the $1.5 million cost. All of the town's injection well plants may experience this same nightmare. This could also apply to plants that use drain fields. It is clear that the DEP does not want these plants or septic systems in either single or multifamily homes. These outrageous costs and bureaucracy are hoping that towns will be pressured into installing municipal sewer systems where mandates have yet to be issued. The FDEP has grant money and assistance available to help with this conversation. If there is a town project being developed, I believe the DEP will allow these plans to continue without these costly upgrades until the sewer conversion takes its place. As you know, I was a member of the Septic to Sewer Committee, and I am quite familiar with the town's needs. When you decide it is time to move forward with this infrastructure project, I will be willing to help in any way to make it happen. Thank you for your time. And I can tell you that I learned last week at elected municipal official training, the city of Sebastian is currently under a DEP mandate to convert because of their proximity to and the effect on the Indian River Lagoon. So it's coming.
All right. Thank you, Ron, through Carolyn, for that presentation. All right, let's go move on to announcements. All right, my first announcement is I'd like to thank the Starbright Association, and specifically Stella Kolb and Carol Bessler for our festive Veterans Day bunting and flags are outside. We have a new flag on the flagpole, the bunting all around there. It's all because of those 2 ladies. So thank you for that. All right, let's see. The meeting schedule for next month is as follows. We have a regular town commission meeting on Monday, December 4th, a community standards on Tuesday, November 7th at 10, and a planning and zoning meeting on Tuesday, November 21st at 9. Board of Adjustment meeting tentatively on Wednesday, November 15th at 9 a.m. All meetings are held in the commission chambers at Town Hall. All right, Town Hall will be closed Friday, November 10th, in observance of Veterans Day, Thursday, November 23rd, and Friday, November 24th for Thanksgiving. The annual municipal election will be held on March 19th, 2024. There are 2 seats on the Town Commission open for 3 years, and 1 seat on Town Commission for 2 years. Candidate filing dates run from November 6th, that's this week already, at noon through November 17th at noon at the Town Clerk's office. Please join us on Friday, December 1st from 5 to 7 p.m. for the annual Light the Lights holiday event, which will be held at the Town Hall Complex. Please check the town's website for more details to come. We have catered food for that?
We are deciding on the caterer, but yes.
Okay, so we have food, beverages, pretty fun.
Games for the kids too.
Oh yeah, we have things for the kids too, even the big kids.
Bring your
Residents,
friends. I said, bring your friends.
residents who wish to sign up to receive the important town notifications and news through Civic Ready should sign up on the town's website or call Town Hall for assistance. All right, now we'll hold public comment.
Yeah, my one little announcement.
Another one? You have another one? Oh, that's.
I just spoke for
Oh, that's
one. This is-
SF.
Right.
This is-
Well, you got me crazy.
I received an email invitation the other day from a group called Incubate Debate to invite me to judge our upcoming debate tournament on December 9th at Palm Beach Atlantic University. Incubate Debate is a Florida nonprofit debate league that hosts no-cost debate tournaments for urban and rural middle high school students across Florida. And our recent tournament on October 7th was joined by students from Miami-Dade, Broward, Monroe, and Palm Beach counties to debate topical issues facing their communities. Sorry. The judges are invited elected officials, law enforcement officers, veterans, and business owners. And I'll give each of you one of these because they said anyone who wants to come. It's December 9th, and I'm going to go from 2 to 5.
Thank you.
Got some interesting debate.
I don't remember.
I got that through the website. Yeah. All right, so let's go move on to public comment. Anybody who has a public comment and wants to speak on it can come up right now. Whatever you're going to speak on, make sure it's not what we're going to speak on later on, Terry. No 2 bites at the
I know
apple.
the rules. Terry Brown, Harvard ISOP. No, I would just make note that before you do the consent agenda, that you're hiring Delray Garden Center. Very creative way that you're doing it, but I'm sure that Christie approved that contract. I don't have any objection to that. I think they're a good company and they'll do a good job. What my concern is, as with CWA, Chris Wayne, is that no one actually supervises the people at the lowest level doing the work. First of all, most of them don't speak English, because I've tried. And just where we live, they mowed down the muley grass while it was blooming. So who's going to talk to these people, and I know that's a good company, about who's going to be responsible for supervising them, be sure that this is what you do here, and this is what you do here. We got that median strip, I think, in pretty good shape right now.
And would you check on that on-site supervision for
Isn't that
Delray
Billy?
Garden Center?
Yeah, so that was the biggest thing about being sure they knew what they were doing. You have a supervisor there, I've seen him at some of the places around. The other thing I wanted to mention was about package plant. You have a big, huge package plant sewer up in the north end that covers all those much bigger places than this place down here. And you're building condos there next to the Ocean Club. I assume someone has looked at the capacity. I know that's the Department of Health. But that's a different type of system that pumps the effluent right into the intercoastal. If the bacterial level is at a certain minor de minimis level, they can pump it into the intercoastal. And that's what's happening right now, right, Ken?
I believe that's true.
Yeah, right into
But
the
it's passed the
Spanish
Bill of Health.
River it goes.
I don't know, you keep looking at me, but that did pass the Bill of Health. That was scrutinized
Yeah,
pretty hard.
yeah, no, and the guy was here once with a meeting and he knows what he's doing.
Yeah.
My concern is that you're gonna approve a project and they have to have capacity there. So someone needs to review that, perhaps the town engineer.
Perhaps.
They've submitted nothing so far.
I beg your pardon?
They've submitted nothing so far.
Yeah, I know, but I'm just telling you, it could be a problem.
Thank you, Terry. Yes, ma'am. Stella?
Good evening, Stella Cole, 204 Beachway. I just wanted to ask a question. A few months ago, I had talked to Jeff and he had said that he would like some art changed in Town Hall. Because these pictures have been up there forever and nothing's getting done. So Starbright would like to, we have contacted local artists, and we would like to have their works shown here for no cost to the town. I just need permission. So if this is what you still would like to have some art here, we'll do it. If not,
Well, I'd like to see some
Jeff?
color.
Can I address that?
Sure.
I had a local artist resident from town that approached me. I was not ready to get it on the agenda this evening, but they are working with several local artists and wanted me to bring a possible item for the commission to approve that would allow them to hang art for sale, to rotate, and do an agreement to where it would have to hang for a minimum period of time before it could move out, but that was not ready for the commission agenda this evening,
When do you think it'll be ready?
in the December meeting.
Okay.
well, she's with Starbright,
Okay.
the resident that you're talking about. So that's the work that's been done. So we were just waiting for an approval one way or another to get it going.
All right, so we'll bring it December meeting?
Yeah.
All right, or the end of December, or January meeting, which one?
No, we would bring it at the December meeting.
December meeting, we'll
Okay.
go over.
Thank you.
Sounds good. Thank you.
Didn't we used to do that?
Yes, we did. That's why we put all these,
And,
that's why all these things are up
So,
here.
so
They
the
have
question I
restricted.
have is, why did we stop? So
Well-
that's the biggest question. So there was a reason why, because we allowed it before, so, anyway.
That'd be the one these Ocean Avenue. We need a bigger parking lot. I had to park way over there to come to the meeting this evening.
What?
We
Parking in
need-
Betty's
Well,
house.
We need a bigger parking lot. Plus
Thank you,
that-
Betty.
The other thing I noted, motorcycles now think they're bicycles. And I've seen two of them run a red light. One of the
Chief, you heard
police
that.
were busy today. I don't know how many people they ran down today. I heard. But, we've got to do something about bicycles and motorcycles.
Thanks, Betty. Carol?
Carol Bessler, 5906 Old Ocean. I'd just like to maybe perhaps help Terry Brown out with the comment he made about the Delray Garden Center. Many moons ago, when I was the vice president of the Ocean Ridge Garden Club, Kimberly Marshall was the president. We put together booklets, of which we still have probably 300, and they're translated into 3 languages. So they're in English, Spanish, and I believe French Creole. And we were giving those out to the local landscapers and gardeners in the area to keep them aware of things that needed to be done in terms of native plantings, trimming, those kinds of things. And I'd be happy to pass that on to Lynn, and she can give them out to the Delray Garden Center and anybody else who wants one.
Great idea. Thank you. Anyone else?
Mr. Mayor, if I may, we do have Stanley Price here, who's the attorney for 6273. If it's appropriate to have him come up at, right now during public comment, and provide an update on the status of that project.
Sure. Right after this gentleman here.
Yeah, I'm Paul Smith from Crown Colony Club. In response to Ron's letter, I just wanted to say that I totally agree that we really need to start considering, avoiding beach sewers and getting away from septic systems. I mean, I installed septic systems in New Jersey, so I know a lot about them. And I just think it's time. I mean, this whole town is built out, so every home's on a system. It's just mind-boggling to me that we haven't considered this earlier. So just wanted to say that.
Thank you.
Good evening.
Good evening.
Stanley Price, Bills and Sunberg, 1450 Brickell Avenue, Miami, Florida. Approximately an hour ago, the 2022 taxes have been paid. The receipt is in the possession of your city attorney. I sent us that receipt. 3 weeks ago, there was a major meeting of the regional members of FP&L to talk about providing the electricity. We waited 4 months, we got the permit. We jack and board under A1A. They told us that because of a shortage of linemen, they would not be able to connect the electricity to our home until February and March of next year. Approximately a week later, we received the call that the pole will go in next week. We hopefully will have electricity to the house by December 1st. And we are asking that if it's within the purview of your building official, we would be prepared to apply for a temporary CO prior to December 31st. And you would be entitled to get your entire ad valorem taxes for 2023 if we get the temporary CO. We believe we'll be in a position to do that. The only thing that's questionable to us right now is we've had a lot of the air-conditioned compressors on the ground now for over a year and a half. And we are hoping that they will be fully operational when the electric is tied in.
Well, they're all on raised pads, right?
Yes.
Yeah.
Yes. We are, as I have indicated to the town attorney on multiple occasions, we want to be in the house before December 31st. It will achieve your objective to getting the entire taxes for 2023, which would be a hit of about $200,000 to my client. But we are prepared to do that. And we'll be happy to meet with your building official and whatever town officials you want and try to get this done by December 31st.
All right. Lynn, you want to take the lead on that?
I will take the
Carolyn?
lead on it as
Christie,
much as I can in November, but I will make sure that the building official is.
we'll make sure that happens.
Happy to answer any questions.
Any questions?
I had a question. I sent you an email. Of the 200,000, what is the number that goes to the town?
It's like 28%.
28%? So 50. So just so everyone knows, it's 50 taxes or 50 fine.
Right, but a temporary C of O comes with another condition per our code or a letter of credit, correct?
Only if it's longer than 30 days. If they need a temporary C of O for only 30 days, it does not require a letter of credit. If they need it for longer than 30 days, they can be granted a 90-day temporary C of O, as long as they provide a letter of credit.
How long do you think you need?
I don't know, sir. It depends on whether the wiring in the house can accommodate the increased voltage that will come into the house. But I would like to remind everybody, we have a $450,000 letter of credit, which has already been posted in favor of the town.
Right, but that's not anything to do with the temporary C of O. So what triggers it then? So he gets 30 days, but if it goes beyond 30 days, what happens?
Then he applies for a 90-day temporary C of O and is required to provide a letter of credit, which, with an outstanding one, I would have to talk with Chrissy, but it may be able to transition, that is for 110% of the value of the
Remaining
improvements that need to be completed.
Can we attach this to the current 450?
To the what?
The 450 we currently have was for demo, right? So can we take the request here and also apply that against the letter of credit? The
Yeah, I think
current- the current
what
letter.
we would do is just to ask to extend the letter of credit to cover the additional time for TCO. If it's going to extend beyond the initial 30 days, we could do that. Yeah.
We'd be happy to transfer it under the temporary CO situation.
That sounds like a quick solution.
So we'll work, Len and I will work with Stanley Price, their attorney, and make sure this all gets done ideally before the end of December, so it's on the tax rolls.
All right.
I appreciate your time. Thank you very much.
So we've agreed to the TCO.
No, we
No, the
don't agree to, the
building
building
official has to
official
do
agrees.
that.
That's where we're getting kind of ahead of ourselves. The building official needs to meet and see if they can do the temporary TCO. And if TCO goes through, then he's got 30 days to finish the house. If not, he's got to do the 90. So we're almost there.
If I may respectfully suggest, I'd like to set up a meeting with the town manager, the building official, and the town attorney within the next 10 days. So everybody will, and I'll have my contract there, and everybody will understand what the drill is.
Well, I'm sure that the town will be amenable to that, so we all want to get this project done.
Except Lynn's going to be out.
I will make
So
myself
maybe you
available
do it.
virtually.
She can make herself
Make
available to
myself
her.
available
I'll
virtually.
coordinate with the town attorney.
Okay.
Set up-
That's perfect.
Thank you very much.
Thank you. Yes, sir.
Good evening. Bill Scarlett, 5700 Old Ocean Boulevard. Just a really quick thing. I walk the whole length of the town pretty much every morning. And I've been noticing that bicyclists are completely ignoring their duty to stop for people crossing the crosswalks. I saw a family the other day. They literally jumped back because these two cyclists just went right through. And I said, you're supposed to stop, and they just kind of shrug or they don't even respond. So, I know you guys are really busy and I appreciate all that you're doing, but anything you could, I'm just worried that somebody's gonna get seriously hurt, crossing one of those walks. Because if they expect bikes to stop, they're not gonna. Thank you.
Thank you. Put on your list, Chief. Anyone else? Okay. We'll close public comment for tonight and we'll move on to the approval of consent agenda. Is there a motion?
So moved.
Second.
Motion and second, any other discussion? Any public comment? Hearing none, all those in favor signify by saying aye.
Aye.
Motion carries. All right, moving on to the regular agenda items. I guess we're going to consider proposals to complete required EAR evaluation and comprehensive plan updates. Lynn?
Thank you, Mr. Mayor. The town is required under state law to complete an EAR evaluation and appraisal process related to the current comprehensive plan, and with the results, draft, and adopt any necessary changes to the town's comprehensive plan. This process needs to be completed with a letter submitted to the state to that effect by March of 2024. Previously, we have utilized Urban Design Studios. We contacted them. The member of staff that normally does that for us is preparing for retirement and they're not taking on new projects. We've subsequently reached out to two groups in Palm Beach County that work on these projects and obtain proposals. The first is from Chen Moore and Associates and Aaron Deedy, and they've got a PowerPoint presentation. You also have their presentation and an example of their comp plan that they have done for another community in your packet. The second proposal is from Place Planning Design to amend our current contract with them to do the EAR and comp plan. And I believe that Jim and Corey were going to be here, but I think that may have been, I had 4 phone calls trying to reach me, so they might be running a little bit late. So we will go ahead and get Nilsa and
No, we're not going to go through a whole presentation.
Right.
We have it in our book.
No, they have a PowerPoint that they want to do for you.
Right, okay.
Good evening, Mr. Mayor, Vice Mayor, Commissioners. I am Nilsa Zacharias, Director of Planning for Chen Moore and Associates, and with us is Erin Deedy from Erin Deedy, PA. It's a true honor and privilege to be here in front of you presenting our proposal, and mainly we are here to answer any questions that you might have from the package that you already received and the proposal. So please, if we can show the first slide. Next, please. So we have a very short presentation for you. So our main purpose is to see how can this team assist the town to accomplish its goals and why we are the best team for these tasks. Next, please. Chen Moore and Associates was founded in 1986. We are a multidisciplinary team of planners, engineers, landscape architects, and we have several offices across the state of Florida. And we are more than 100 full-time employees, and we serve a number of municipalities. The project team for this specific initiative, which is to update your comprehensive plan, I will be the project manager. I am a certified land use planner with over 25 years of experience. I am a Fulbright scholar that has been serving municipalities across the state of Florida and working one-on-one with city attorneys, town managers, and definitely with commissioners. And part of the team, we have a group of planners and engineers, and mainly we also have Ms. Erin Didi that I would like please to invite you, Erin, and introduce yourself.
Thank you.
Sure, I'm Erin Dady. I'm a consultant and I'm an attorney. My office is in Delray Beach and I have a pretty long history working on land use issues.
Yeah, you used to sit up here, right over there in that
Immediate
seat right over
area.
there.
Yes, some of you, yes, I know you. Anyway, I've done some work recently in Delray Beach, Briny Breezes, locally. My focus on the project would be dealing with coastal issues, and I worked on the climate change vulnerability assessment. I was a subcontractor that you participated in with multiple local governments locally. Thank you.
Thank you.
Next slide, please. The specifics to update a comprehensive plan has those 5 main steps. And the first one is to look at the existing conditions. We, Erin and I, actually last week, we were looking at your existing comprehensive plan, very preliminary, and we did realize there are several parts and elements that need to be updated. So the next step is about visioning workshop. We would like to meet with all of you, with your residents, and listen the ideas, because the Florida statute now is requiring a 20 years planning period. So then we will look at every goals, objectives, and policies of all the chapters of your comprehensive plan, updating accordingly with the data and analysis. Data and analysis is key at this point because we have now the 2020 census. We finally have all fresh data that your comprehensive plan will benefit from that. And then definitely we'll start the approval process and the transmittal to the state. Next slide, please. So that's the summary of all the different tasks that will entail to update the comprehensive plan for your town. Next, please. This is a summary of all the different municipalities that we have worked. Either I have worked on my team, or Erin had worked also updating comprehensive plans. And just to show you our capability, this is a whole entire comprehensive plan. What I submitted, and it's part of your package, is just one little chapter. So this is actually the document that you will be receiving as the final product.
We have.
Yeah, we have just one part of it.
We just have one
She's
part of
saying.
that monster book? Okay.
So this is the
So we have tremendous expertise in Palm Beach County. We also have full knowledge of the Florida statute with regards to sea level rise, resiliency, and we have worked in comprehensive plan for so many municipalities. We are here to answer any question that you have from the proposal that we put together to your attention. Thank you.
Thank you. Now, we have Corey Goodwarman's not here, or?
I think he's running late, so.
So
better
I do have a
unable-
question.
Yeah.
And I'm just gonna get right to it. We're stewards of the town's money. And your proposal is 20,000 more than the proposal we got from our existing town planner. Now, can you kind of maybe give us some kind of enlightenment of why there would be so much more?
I can definitely say that we will review every chapter. I have not seen Mr. O'Gorman proposal. I don't know if he is proposing to review every chapter. There are more than 6 chapters on your current comprehensive plan. So we will review each of them and update it per the Florida statutes. So you can update a comprehensive plan in many ways. I don't know if he's doing a surgical approach just to specifics, specific chapters, or he's doing the whole comprehensive plan.
Well, I guess my question was, what do you bring to the table, not comparing the apples to their proposal? What do you bring to the table that makes you feel that you're much better than they are? And I noticed with all those cities you're with, but anything else?
Yes, we bring together Erin expertise that she is a pro when it comes to resiliency, coastal management, sea level rise. And we have looked at last week your comprehensive plan, and some of the chapters or elements, they are completely lacking of that sea level rise policies. So that's, like I said, this is what we bring to you. I'm not sure what Mr. O'Gorman is bringing.
Thank you. Any other questions?
Yeah, I have a question on the resiliency that you guys worked on, right? What did we get out of that?
Helped us with our grant applications.
Well, right.
It sufficed for that, can't remember what it was called, but the initial phase.
Yeah, but I just think that's a political issue, but go ahead.
So the state of Florida has invested about $2 billion in infrastructure and resiliency projects since 2021 when it passed the Resilient Florida legislation. And a pathway to access that money is your climate change vulnerability assessment that you partner with multiple local governments on. In fact, the way the law reads, after 2024, you're not even eligible for cost share funding for some of your infrastructure projects. I don't know the status of all your infrastructure, but I was just listening to your presentation about wastewater. You've got some challenges. So you're probably going to want to be able to access programs that could provide you up to 50% cost share, and that vulnerability assessment is key to doing it. The second part is it provided a lot of data in terms of different types of flooding conditions. They require you to look at sea level rise, tidal flooding, storm surge, and you can take that data now and you can integrate it into your comp plan to help you support better policies to react to that infrastructure flooding data.
So you're saying the town got a final report on that? Because I didn't see that, but I might not have been on the commission at the time.
Yes. You did. You got a report, and as somebody who is a subcontractor on that team, I can tell you when we were writing the words "the end" on the report, our Florida legislature was enacting the Resilient Florida legislation, which required a whole lot more in terms of flooding analysis. And so that report was updated to incorporate those new requirements. And I'm happy to report that that multi-jurisdictional vulnerability assessment was the first in the state of Florida that was found in compliance with these new requirements for VAs. So you guys are kind of on the leading edge in terms of locally partnering with other local governments and having that data and having a vulnerability assessment that sets you up for future grant applications.
Okay, thank you.
So maybe you can answer a question that came up. When was this vulnerability? 3 years ago?
21, I think.
I was against it because our town engineering firm already has the exact same conclusions. They came through and did a flood evaluation for the town.
Mm-hmm.
So do we need the resiliency stamp to get grants, or could we have used the town engineering report?
Well, the way the law reads, it's in subsection 5 of 380.093. It essentially says to be eligible for project funding, you have to have a compliant vulnerability assessment by 2024.
But that's my issue.
But now you have
Does the one
it.
done by the town engineering firm qualify?
No.
So this is a political thing where you have to spend the money on the resiliency in order to get access to the grants.
Well, your vulnerability assessment was 100% funded by the state of Florida.
No, we kicked in.
We all paid for
Yeah,
it.
27,000 or 17,000.
Oh, okay. Well,
by
the
town.
planning work, maybe you put up a match to make it more competitive to get that grant. But
No,
for the
we were
most
told-
part,
No, I don't think
needed to
we
spend
got a
it.
grant for it at the time, but we've now used that vulnerability assessment to apply for a number of grants this year.
Okay.
And we otherwise would have had to complete that step had we not already done it.
And I believe your update to bring it into compliance with state law was funded by the state of Florida in a planning grant.
Okay.
That answers my question. Thanks.
Sure.
Any other questions?
I think what is due April 1st? It's the evaluation appraisal notification to the state, correct?
It's the letter. All
Okay,
what is due on that date is the letter saying to the state, yes, we are going to update our comprehensive plan. Before 2011, it was mandate every 7 years to do this. After 2011, every municipality can decide if they would like to update or not. So most municipalities their comprehensive plan is outdated, they decide to do so. And once you submit that letter that goes in April 1st, then the state will give you 1 year to adopt, and that 1 year is not enough time.
Yeah.
So, and that's the reason, if you already know that you need to update your comprehensive plan, I'm very happy that you are already taking the steps to consider and to start early.
thank you.
Thank you.
Thank you.
Now, Mr. Mayor, I did hear back from Mr. O'Gorman, and he has hung up at another event and is not going to make it this evening.
Okay, so I have a question for you and Christie. So you went over both these proposals?
Yes.
And matching them, are they similar?
In my opinion, the approach that Chen Moore and Aaron Dede are taking is more of an in-depth, comprehensive approach where you involve the commission, you involve public input to get a better understanding of the town's strategy. And since it is now a 20-year planning period, it's more of a comprehensive update to your comprehensive plan. I think the second proposal is more of a straightforward, let's make sure that we're satisfying all the required statutory obligations. So it's really at the pleasure of the commission, what kind of update you're looking for, one that sort of checks off all the statutory requirements, or one that allows for the commission and the public to have more of a involvement in, let's really set forth what our goals are for the next 20 years and create a comprehensive plan that we don't just refer to every now and then. That's more of actually a planning tool. I think that's the main difference in the value, because there is a difference, obviously, that you noted in the cost of each. And I think theirs is going to be a little bit more in depth, a little bit more comprehensive. So it kind of depends on what the pleasure of the commission is, which way you want to go with it. I mean, Corey O'Gorman certainly knows our comprehensive plan as it exists now. He knows our code as it exists now. So there's a benefit for having that knowledge and experience. And he can certainly work with the other gentlemen to bring forward something that will be compliant. And I think they are willing to do more comprehensive. They just didn't include that as part of the proposal.
In looking through our comprehensive plan as it is, it's seriously outdated. I mean, the zoning maps are completely non-compliant with what we have in our code. I think there's a number in there for water infrastructure budget of $10,000 a year. I mean,
That's why we're doing this.
Right.
I know.
That's the whole
It's
purpose
outdated.
of it.
It's
Yeah.
outdated.
That's why it has to be done, so.
When you say they're willing to do more comprehensive, you mean underneath the quote given here of 30,000, they would do what you just described?
I think so, because I think they also provided an hourly rate. So if there's proposed scope of services didn't have, like if the commission wanted to have sort of a planning or goal setting strategy session, that they would, be involved in that. If you wanted to have sort of a town hall meeting to discuss goals and objectives for the next 20 years for the town, then they would just charge your hourly rate for that.
And there's
So-
a not to exceed number in there.
Correct.
What was that, Ken?
There's a not to exceed number in there.
But it's on top of the 30. That's my point.
Right.
Well, but Corey said that O'Gorman would say that he would do more comprehensive if we wanted him to.
Right.
But I'm sure that would increase his price.
Yes.
They're not doing it for free.
It's our.
Right, if you look under the additional amendments, it says the town at its discretion may request additional comprehensive plan amendments during the completion. Those would be subject to the hourly rate.
and we haven't really seen, they haven't spoken to it yet, so.
Well, Mr. Fleshman.
No, he did not come with a proposal last month. He was thinking on his feet with numbers and whatnot.
All right, so it's a pleasure, Commission. I think that in my own perspective, I'm not liking the $20,000 difference, but I think that the way that you're doing it and involving the people, the town, the staff, and it's a 20-year outlook, it's kind of important we involve everybody in that comprehensive plan. What was that thing you did years ago?
Focus 2000.
Focus 2000. We did the same thing, yeah. Remember that?
Remember it well.
But that's just my personal opinion, but what do you think, Phil?
Yeah, I think it's too important. You're going out 20 years, you better, have everybody on board of what you want to do. And there's a lot of issues, and we keep finding more and more with the pipes underground, the sewer system now, or the septic system that are going wild. I think we got to do the job right,
And we
saving 20 grand and then not doing it right.
And we have a lot
Could
of,
cost a lot.
valuable expertise in town, people who could, help us with that.
Gentlemen?
Well, it's unfortunate that Corey couldn't be here. And so I would like to hear from him before, and their presentation before we make any final decision. There's no reason why we have to decide this tonight, to my knowledge.
Other than
I see
it's gonna
some,
take more than a year.
I see some advantages and disadvantages to both. And I'd like to hear and ask some of those questions. We have a limited amount of things we can really do in the town. And I agree with getting people together and doing those focus groups and charrettes and whatever we need to do. But there is a finite amount of things that have to be done, and it's pretty much targeted as to issues. And so I'm really concerned about what is being brought to the table. Do they have knowledge with those issues? And that's a concern. I know, great presentation. I know your history. I know Aaron. So I know their knowledge is there. Corey has, a lot of familiarity with the town, and working with Christie. I mean, either way, it's gonna be involved, with the town attorney, so there is going to be overlap. So I wanna hear from him before we find, I kind of feel like we owe it.
So why don't we postpone this till next month then?
Agreed.
Is that a consensus? So I'm sorry, ladies, but I think it's only fair.
But you don't need to come back in December.
Well, I would.
We don't.
To advance your questions. All right.
Thank you very
Thank
much
you.
for coming.
Thank you.
All right, let's move on to number 11. Approval on second reading of ordinance number 2023-04, an ordinance of the Town of Ocean Ridge, Florida, amending its code of ordinances at Chapter 67, Article 2, entitled Coastal Construction, to clarify and revise the town's coastal construction regulations for all development and construction seaward of the 1997 Coastal Construction Control Line and seaward of the 1979 Coastal Construction Setback Line, providing for repeal of conflicting ordinances, severability, and an effective date. Then miss one this time. Go
Thank you,
ahead.
Mr. Mayor. Yes, this is second reading for the ordinance that is going to relax some of the standards for our coastal construction control line. This ordinance 2023-04 changes the current sort of limitations put in place in 2020-05, ordinance 2020-05, which required basically a variance for all construction seaward of the 1979 Coastal Construction Control Line. What this ordinance does primarily is it allows for administrative process for some of that construction and allows for variances to remain in place for primarily new habitable structures seaward of that Coastal Construction Control Line. So we've been over this several times. I'm happy to answer any questions you may have.
I had a quick question, Christie. The first reading was at the July meeting, not the August meeting. That's when we did the first reading of both. They were approved in October, but we actually did it in July.
Correct, you're correct. What happened was I made some tweaks after the July meeting, and we decided, since at that time we had some attorneys involved, to bring it back for first reading in October, just so that it was a clean slate. So what you had before you in October was the final version without further revisions.
And then one element that isn't included here was the removal of 67-17G, which was one of the very important elements of that of 2020-05.
Yes, and that has been removed.
No, but it wasn't included in your narrative as a.
I think just because that was removed back in the July version.
Are there any other questions? Make a motion?
Make a motion to accept ordinance number 2023-04.
Second.
Public comment. Hello, Mary Lee. Hey, you're back.
Marilyn Lundquist, excuse, 6277 North Ocean Boulevard, excuse me. I appreciate what you're doing now. Okay, I appreciate very much what this council is doing, and but I will not go easily, okay? Ordinance 2020-5 was passed during COVID by a previous mayor. I hope I get through this. Mayor, previous town council, previous town manager, previous planning and zoning, and advised by a previous town attorney. I don't know if the whole town knows what this ordinance did. But basically, I think there were good intentions. They thought it would help climate change because they felt that the ocean is going to rise. Basically, all this property back in the late 1800s, excuse me, was the Boynton Beach Hotel. And they did have a beach there, and we still have a beach today. It could have been about protecting the dune. Well, the dune is protected federally. You cannot even walk on it or even build on it. And I'm sorry, my voice is so bad. The Army Corps of Engineers, the state of Florida, the town of Ocean Ridge has never done a beach, a dune restoration. The private property owners have. I've done it 3 times. People have built seawalls to protect it. So anyway, I don't know how that would protect the dune. Now, and then we have the bridge, which is special to this town. When the town of Ocean Ridge wanted to take away counting the beach property that's owned, the dune property, which we own and pay taxes on, and the ridge property, and every single property on the beach in town is within the ridge and within the zone, which was basically like a no build, no improvement. And if you could rebuild, half of your lot was not usable, the lot closest to the ocean. So any house built would be much smaller. Okay. Well, anyway, I appreciate the fact that this is, but damage was done. There were several real estate transactions, and it was very damaging to the town. And, you know, this was done by our neighbors who we elected, people we employed in this town. And this is a small town. And, you know, we're all afraid what the government's going to do for us, but look at what happened in our small town. We were not informed before this was happening. After it was passed, there was no information given to homeowners. For 2 years, people did not know this was in effect. And this is very serious and should never, ever happen again. And I hope people that don't understand. Thank you.
Thank you, Mary Lou.
Sorry I went over.
Thank you.
Any other public comment? All right, back to the commission. Any other discussion? Hearing none, all those in favor signify by saying aye.
Aye.
Motion carries. All right, approval on second reading of ordinance number 2023-05, an ordinance of the town of Ocean Ridge, Florida, amending its code of ordinances at chapter 64 zoning, article 1, district regulations, section 64-1, RSF and RSE single-family residential districts, subsection 64-1J, RSF is single-family residential property development regulation, to identify the 1979 coastal construction control line as the rear setback for lots adjacent to the ocean. It also amends the subsection 64-1K, RSE, single-family residential state property development regulations, by declaring 14 parcels of real property bordering Old Ocean Boulevard between Anna Street and Corinne Street as conforming lots of record under the residential single-family estate district requirements for minimum lot size, lot width, and/or lot depth as applicable. It also creates a new subsection to provide specific development regulations for the identified 7 parcels of real property on Old Ocean Boulevard between Anna and Corinne Streets, and providing for a codification, severability, conflicts, and an effective date.
Thank you, Mr. Mayor.
You're welcome. That's a lot of words in there.
So this ordinance 2023-05 is the ordinance that grew out of the Mr. Papa's property and the issue that arose out of redevelopment of his property on Old Ocean Avenue between Anna and Corinne Street. And recognition that the lots there are non-conforming, some legal non-conforming, some not legal non-conforming lots, and wanting to allow for them to be redeveloped with some development restrictions, but more of a relaxation to allow them to redevelop reasonably. So this creates a sort of an overlay for those lots to allow them to redevelop without having to go through a variance process for lot size, lot width, and/or lot area, depending on which nonconformity they suffer from. And this sort of coincides with the ordinance that was just adopted to sort of clarify a lot of our CCL construction-related issues that we've been dealing with since the ordinance 2020-05 was passed.
All right,
So I'm happy to answer any questions.
thank you.
You're welcome.
Is there a motion?
Move to adopt 2023-05.
Second.
Motion and second, public comment. All right, hearing none, back to the commission. Any other discussion? Hearing none, all those in favor signify by saying aye.
Aye.
Motion carries. Thank you, Christie.
Thank you.
Thank you for all that work.
6 months.
6 months.
Well, so now, okay, you open the door. When you have a little preaching, but think about that for a moment. The impact that 2020-05 had on all those residents and all those properties, and this commission did not go through that detail.
No,
So let
let's
that-
clarify, not this commission.
No,
That
that
commission.
commission.
And in 2021, I tried to bring it up and was.
Well, I definitely brought it up. But,
We both did.
if, we should keep that in mind and pass it on down to future commissioners, that when something comes before them, that they really ask the hard questions, that they really look into it and challenge the town attorneys, whoever they may be, because they're not always right. And that's just the way it is, but you have to pay attention to that stuff, and we didn't. And there's a lot of misinformation. I'll bring this up. I think we got that email from the Mary Kate from the Coastal Star about that property and, that thing. And I think so that there's not a misinformation, let's take 2 seconds and let Christie explain how that thought is not correct. That belief. I think you sent us a
Structural
memo.
envelope.
So are
And
you
the
talking
impact.
the impact of this?
Yeah, and then anytime you try to target a particular property, a red flag should go up. we shouldn't be doing that, a particular piece of property. And that's always dangerous. We're not in the business to target people's property like that. But anyway, if somebody wants to answer that, then, you know, but I think Mary Kate raised a good question, not faulting the question, but it's from not fully understanding how this ordinance is employed. And that's our job, is to make sure that that's communicated.
It's also how the ordinance protects against what she thought could happen.
That has that element in it, sure.
I'd be happy to speak to that because I responded to her right away when we got that email. I said, "Hi, Mary Kate, thank you for reaching out and for your concern, which I share. I actually reached out to the listing agent to make sure she understands our laws and what would and would not be allowed. Christie advised that any buyer or the listing agent doing her due diligence should request a zoning confirmation letter and perform a title search. The listing agent was appreciative of this information and has actually already conducted a title search. Under the new ordinances, a buyer would not be able to do anything outside the structural envelope as it is. They cannot build up or out. In addition, under our FEMA maps, both adopted and proposed, you'll hear more about this on Monday, the property is in a high hazard flood area. As such, no renovation or substantial improvement can exceed 50% of the market value of the structure. Papa has the assessed value of the structure at $368,000. That would limit the money any buyer could spend on renovations to $184,000, unless they got another appraisal. I believe our carefully researched ordinances, as written, have provided us with the protections which we all want while restoring the rights to homeowners that were inadvertently taken away with Ordinance 2020-05.
Okay.
Just to clarify, because I responded to Mary Kate as well, the reason this ordinance took us 6 months, and Christie probably longer than that, she says, is because of exactly what Mary Kate was asking, what Carolyn's bringing up here. We really looked at this from all angles, and then the final thing we threw in there was the term structural envelope. So the structural envelope of these properties cannot be enlarged, and that's what protects us from what Mary Kate was worried about, which is a mansion coming in and replacing a 2,800 square foot house that's in the sand. That cannot happen.
Thank you. All right. Okay, let's move on to number 13, discussion of the town commission appointments. Christie? All right, open it up to you to explain to us the voting procedure, which was something I recently learned.
Yes, thank you, Mr. Mayor. Per the town charter, section 3.06 of section C, when there's a vacancy in office, which can be a resignation, the remaining commissioners that are not resigning are the ones charged with voting for the replacement. The commissioners that are resigning are not allowed to vote on the issue. However, the charter doesn't speak to their participation in a discussion relative to their replacement, but they cannot vote. So when the resignations are presented or a resignation is presented and a vacancy occurs, remaining commissioners are the only ones who may vote.
All right, so everybody got that? Now we did not publish the resumes of the people that applied, have we?
I did not publish the resumes, I thought it was just a discussion. But once we decide to have a meeting, I can publicize those resumes.
Now, would it be a good idea to have a special meeting regarding this?
Yeah, when would be the quickest we could have a special meeting? Could we do it this week?
I can do it this week. We can do it this week, Wednesday, Thursday.
Lynn, you
Well, you got a
disappeared.
notice requirement.
Yes,
that you may not.
Thursday would probably.
But isn't the notice requirement just 2 days?
Ideally, with a decision about appointments for replacement commissioners, you want to provide as much notice as possible. There's no set time frame under sunshine law, but the Attorney General usually recommends at least 7 days.
But when did Civic Ready first go out alerting people to this?
It was like the day after? It was the day
What's a
after
notice of the meeting?
The last meeting.
Well, I'm talking what we need to have occur legally for a hearing. It's very loose. it hasn't been determined, so we could do a meeting on Wednesday or Thursday to appoint two councilmen.
If you would, if that is what the desire of the commission is, I would recommend, strongly posting more notices than we normally do, just to make sure that word gets out. But yes.
And by more, you mean just more alerts, that kind of?
More alerts and making sure that the usual suspects are certainly aware of it.
So as not to think, I think public perception council-wide. Why not just schedule something next week? Why does that be Thursday?
Because there are certain people that are interested in being appointed,
Yeah.
but they don't want to be appointed. They would have to file the candidacy papers before we get around to appointing them.
But that still gives us enough time, though. We had the meeting next
What's
week,
the
so I think the
candidacy period?
filing period is, what, the
But
17th?
Christie just finished saying we could
The
have
end,
this
yeah,
week.
the deadline is 17.
It started today, ends on the 17th.
I'd prefer to do it this week.
Well, Chrissy, can we do it this week or not?
You can do it this week, like I said, there's no set time frame for reasonable notice under the Sunshine Law. The Attorney General recommends 7 days, but as long as you can show that you made efforts that were reasonable to get notice out for the meeting, then you can do it in less than 7 days.
You guys open for this week? Phil?
I'm not, I'm leaving on Wednesday.
Well, Phil doesn't have to be here. It's
No, he
Carolyn,
doesn't have
Jeff,
to be
and
here,
Steve.
but I thought if you want to put your
It's the
input
three
in.
of you,
Right.
it's really the three of you that has to be there.
All right, switch your schedules.
I mean, I
I'm
can't
open.
do it this week.
Thursday's good.
Wednesday or Thursday's fine.
What time?
3 o'clock?
3 o'clock Thursday? Does that work for you, Karen?
Can you notice it that early? Can you notice it that fast?
It's 3 days.
Yeah, tomorrow.
Okay.
I would not be available to attend.
Right.
Not even remotely that day.
Okay.
What were you thinking?
Chris, you'll be here.
I'll have to find coverage.
Coverage?
Yeah, I'm out of the country starting Wednesday.
Okay. Chief, you'll be here, right?
I'll be.
All right, so Thursday at 3?
Is there any way we could do it on Wednesday?
I can't do it tomorrow, Wednesday.
Okay.
Thursday it is.
Hmm?
Thursday it is.
Thursday it is at 3 o'clock.
Okay.
I won't be here, that's all right.
What's that?
I said I'm not available this week, but that's okay. I don't have to be here.
All right.
Now, Christie, do they have to go 3 out?
Yeah.
Yes.
It's got to be 3-0.
Okay.
Oh, actually, that's a question. So let's say in the first ballot, because we'll be using the ballot system, correct? So in the first ballot, it goes 2-1. Do you need to do a second ballot?
Yeah, because it's going to be 3-0.
Right?
You need 3 votes.
Right.
Yeah.
That's what I'm asking
Yeah.
versus, and does that ballot have to be on a piece of paper? Or can a commissioner say, since it's 2-1, I'll change my vote? Because we need to have a majority.
The town clerk can correct me if I'm wrong, but I believe we've always done it by ballot just to have it in writing officially.
Okay.
Yes, by ballot.
All right, so that's questions answered. All righty, so moving on to 14, consider the request to waive alarm monitoring and late fees for 5572 North Ocean Boulevard, number 22D for 2023. Christie? Is that you or is that Lynn?
That's me.
All right, Lynn.
The owner of 5572 North Ocean Boulevard, number 22D, has requested a waiver of the alarm monitoring and late fees due to a misunderstanding by the longtime tenant that requested to terminate the alarm services required by the town, but did not do so in writing. The tenant called and spoke with a member of town staff and was informed of the written notice requirement. Unfortunately, this did not translate into action. What we have is a resident that purchased an adjacent unit and provided a life lease to its tenants, one of whom has passed. And the remaining tenant, one of our more elderly residents, did not submit in writing the termination for the alarm fees. That is normally a requirement, and I would normally tell you that the town should not waive any fees, but I think in this case, due to the circumstances, the unexpected stress that the tenant went through in losing their spouse.
How much are we talking?
So, yeah.
I was
We're
just gonna
talking
ask.
about $260
Move to waive
plus 5%.
Move in second. Public comment?
You already spent more than that on town time.
Public, any other discussion? Hearing none. All those in favor signify by saying aye.
Aye.
Motion carries. All right. Number 16, discussing related to participating in the public accessible website for advertisement and public notices with Palm Beach County.
No, you missed one.
15.
You
What's
missed
that?
15.
Oh, I read this. Discussion regarding hold harmless agreements and building departments, permit applications. Boy, I'm trying to move ahead.
Yeah, you are.
All right, so let's
That
go.
would be me, Mr. Mayor. In 2020, the town adopted language in section 6732, floor elevations that require the town to use elevations set forth in the best available data, provided that the property owner meets all of the requirements for the code. The map that is utilized as the best available data has not yet been adopted due to an ongoing appeal by Palm Beach County that is anticipated to be resolved in January of 2024. The town has been using that map since 2020 and adopted the best available language in 2020-7 ordinance. However, in 2021, the state legislature passed the law, section 553.73, subsection 5, that prohibits a law, ordinance, rule, or other measure that has the effect of imposing land use changes or permits, which by form supersedes 2020-07. Though the town has, since the state law passed, not had an issue with properties regarding agreeing to building to the higher base elevations, the town currently has 2 projects that are in the development planning stage that are seeking not to build their additions, which do meet the 50% substantial threshold at the higher elevation. Construction at the lower elevation could have long-term impacts for both the property owner and the town. Concerns include issues for the property in obtaining flood insurance once the construction is complete, potential issues with future transfer or sale of the property due to the base elevation of the new construction, issues for the property for any future reconstruction, concerns that permitting properties to build at the lower elevation will impact the town's ability to raise the elevation on streets to prevent or reduce flooding. Concerns that permitting properties to build at the lower elevation will impact the town's overall CRS rating, impacting all property flood insurance premiums. Concerns that if there is a negative impact on the property in terms of value, ability to obtain flood insurance or homeowners insurance, or with the transfer or sale of the property, the town and its representatives may be held liable or deemed negligent for permitting the construction. With the short time frame between now and the decision on the county's appeal of the new flood map, it would be reasonable for the town to consider alternatives, possibly even a moratorium on new permits for projects that are not compliant with the best available data proposed maps until that decision is rendered. A possible remedy has been developed, which includes a letter to any property owner that is considering building at the lower base elevation, which is to be signed and filed with the property records of the building department, as well as a hold harmless agreement to be signed and filed with the county. However, at this time, if for some reason a property owner were to choose to build at the lower elevation but is unwilling to sign the letter and the hold harmless, the town does not have any action or way to protect against possible liability negligence suits. It could be presumed that the town and its representatives would have immunity until it is tested, and there is case law that fully supports the immunity. In this or similarly related instances, the risk to the town and our representatives exist.
All right, Chrissy, so really, what is our liability?
Well, right now, as town manager stated, there's a state preemption of the law, that ordinance on our books where we require people to build to the preliminary FEMA maps. So right now, by law, they can build to the current sort of old FEMA maps. So from a purely legal standpoint, in some respects, our hands are tied. So if someone were later to say, town, you were negligent in letting this property owner build to a lesser standard, we would simply at that time point back to this law. However, we do have consultants that we work with in any development that goes through the building process, and whether sovereign immunity would extend to them or not is sort of always an unknown. So in a discussion about this issue, the idea of creating this letter to put folks on notice, so we would have Exhibit B, and in any such litigation that they were put on notice of potential consequences if they build sort of a lower level at this point. And then in addition to that, perhaps a hold harmless. Now, my concern with the hold harmless is if someone says, I'm not gonna sign that, then what is the town gonna do? Which led into a discussion of whether or not the town should be considering some type of moratorium to sort of try to put a hold on this issue until we can get a final decision on the FEMA maps. From a pure town perspective, I don't believe that we could be held liable if someone were allowed to build to the lesser standard, because that is right now the state of the law in Florida from a state law perspective. It does perhaps leave a big question mark for the town's consultants that are involved in the building processes.
All right, so right now, basically we have three choices: do nothing, do the whole harmless, or do a moratorium. Are you saying?
Right. Your sort of mineral decision is you just require the letter to go with the building file, the property owner signs off on it, but you also require the hold harmless. If they don't sign off on the hold harmless, are we still gonna issue the permit?
Can I speak to this for a second? Because some of the correspondence that's gone on is not included in the packet. So none of you have had the opportunity to see it. So we started with a conference call after many discussions about one property in particular, and I believe now there are two properties we're talking about. So this is not changing policy for the town. We had a Zoom call on October 4th, Lynn, Christy, Lisa Trepepi, Tara, Kelly, and myself. Hour and a half we were on this call and discussed all of these, save for the moratorium. That never came up. And we were all in agreement following that conference call that this was a great way to move forward. A week went by and I checked in with Lisa and I said, have we seen anything yet? She said, yes, Christy wrote a great letter and a hold harmless. So I sent an email to everybody. Can we please see the letter and the hold harmless? She forwards them to everybody. And after that is when the whole issue of a moratorium was even introduced. It was never discussed before. And at first my reaction was, well, it's redundant. If our ordinance 2020-07, another ordinance passed in COVID, is what we're following as our policy, then a moratorium is redundant because that ordinance wouldn't allow it. However, the House Bill 401 was a preemptive bill passed in 2021 that said we could not enforce best available data. And I'm questioning, even under Senate Bill 250, would we even be allowed to enact such a moratorium?
So I guess
That's
my
a question
question
for you, Christy.
and my question is, well, isn't it all redundant? If we don't have a code for it, and even if we didn't have the hold harmless and I didn't sign it, if I'm doing my permit, we still would have to issue the permit, period. Now we could say, oh, we're not going to issue it. Well, on what grounds? So I'm wondering why.
Well, here's another thought.
Go ahead.
So given that, somebody signs, now we're getting into the legal morass, and somebody signs the hold harmless, all they have to do is say.
Can't hear you when
All they have
when
to
you're
say is, wait a minute, there's a duress there, and, I didn't have to, and in order to get my permit, I was forced to. And so now we're creating, I think we're just creating a bigger mess than, I know it's all good intentions, but I don't think it either we can issue a permit or we can't. It's really a simple concept. I don't have a problem with the notice provision at all. I mean, you're notifying them, they acknowledge it. Knowledge, and we have a judge in the room, knowledge goes a long way. If they still proceeded to go forward, there's a defense built into that. But to create a part where we're forcing somebody to sign something when they didn't have to is creating a legal problem for us. And there's plenty of ways to get around it.
How do
Plenty of
we
ways.
get
Which,
that?
and could be worse, because now we're setting a different precedent. What else didn't we tell them? And now we're forcing, I mean, it's.
So the
really
state law
going down
basically
a-
preempts whatever we pass during 2020, correct?
To my knowledge, that one
Yeah.
does.
So a question, legal question, since you guys are
Public
both lawyers.
comment.
This notice that Ken mentioned, he's just taking a different direction. Instead of a hold harmless, the town sends a notice to the people that they're building. And then how do we get an acknowledgement of that notice? To
So
Ken's point.
Well, they can sign a
there's,
receipt.
so there was,
Something.
There it is.
that was-
It's like a hold harmless when you think about it.
that was sort of the
It's a
the fallout of our conversation. The first thing I drafted was a letter to the property owner from the town that says, okay, we have an ordinance on the book that says you're supposed to build to the preliminary FEMA maps. There's a preemption in state statute that allows you to build under the current finalized FEMA maps. We want to put you on notice of here's potential consequences if you build to that lower level. Please acknowledge receipt of this letter. That was,
Perfect.
that's the letter. That's the notice that I believe Commissioner Khalil was referring to. The hold harmless was done on top of that to provide further assurance to the town and its representatives that the property owner then wouldn't come back and sue us because they, built to a lower standard, which then led to a discussion about what happens.
Would the acknowledgement of notice be, I guess it wouldn't be as strong, but would it accomplish the task that the individual wouldn't be able to successfully sue us?
We would certainly have proof that they were on notice from the town, that our hands are tied from a legal standpoint, and here's potential consequences. There could be other potential consequences, and they sign off on that.
You could do that acknowledgement letter as a standard part of the permit process. I mean, that's easy as that.
That's exactly where it would go.
Public comment.
Oh,
I'm sorry, Phil, you want to say something?
So we're saying basically we want to do the wrong thing because our hands are tied. I'm suggesting we do the right thing, and in 3 months, aren't they going to change this
They've been
over?
saying that since 2019. So to hang your hat on FEMA making a decision by January,
So you're suggesting the moratorium?
Yeah, or
Yeah.
something, or a
Yeah.
delaying, or however to do it, because basically
We
we
don't
know
know
we
when
shouldn't
that-
be building ground
But
level,
right
right?
now,
We
we
all
don't
know
have,
that?
we don't have a zoning in progress in order to have a moratorium. Well, I guess arguably that could be a zoning in progress, but is that violative of the state statute in and of itself?
Yeah.
So, I mean,
and what about 250?
I can say this
Same
on
thing.
moratoriums. There are cities passing moratoriums right now on preemptive state legislation that has come down. So it would not be unheard of. City of Doral just passed an ordinance for the Live Local Act. Other cities in Palm Beach County are considering a zoning in progress or moratorium for that type of legislation. So it's not unheard of that cities are doing moratoriums, even though there is a preemption state law.
Okay, but let's think about this, right? We just had the resilience thing study done, right? Everybody's telling us how we're supposed to build higher, right? The roads might have to be coming up. Miami's spending hundreds of millions of dollars figuring all this out, and we're going to do it ground level. So does this make sense that that law was passed to preempt everybody from going up? So what happened there? Was it a political game? Was it a big development that had to go in?
What happened with Form 6? It's the same thing, preemptive legislation.
Now, remember
It's
this.
not in our best interest necessarily, but
Well, remember, we're not building a new house. Okay, this is a remodel.
It's
It's
not
a
actually
certain
a remodel,
remodel.
they're additions, and at least one, it's a significant addition.
It's
But
just,
it's more
but
than
again,
50%, right?
then you're missing the point. That's what exactly right. It's not a new house. So a new house would have to be built up. An addition is an addition, whether it's a significant addition or a little addition, it's still an addition. All right? So to say to somebody, okay, you can't do an addition because it's 50%, even though there's nothing in the code that says they can't do that. So you're saying that I can't do that because there's nothing in my code because you've decided that it may be detrimental to me. So the town's deciding what is best for me. That's what you're saying?
I'm glad you brought it up. There's no discussion here whatsoever that it's the homeowner's responsibility.
That's
Why are we sticking our nose in here and telling a homeowner what they can do when we don't have a law or a code backing us up telling them?
Well,
and as far as Phil's saying, we're doing the wrong thing, we were doing the wrong thing. With the bill that we passed, the code we passed in 2020 was sold to this commission in this town as a FEMA enacted map. That is not true. And that's the whole reason that we enacted the code and went to the 50% rule and all that. It was bad information provided to the commission.
And it's two properties that were in a X zone, safe zone, per the adopted maps, that now with the preliminary maps that we want to refer to are no longer in a safe zone. They're asking to do what they want to do without having to comply with the
So is
higher
the rest of the house ground level now, or whatever level it is? So when they put the addition on, all they're doing is putting they're adding to their first floor.
That's correct.
They're not
East or
increasing their
west,
elevation.
not north or south.
Now, the other thing is that
I don't know what
the
house
the
it's
notion
dealing
that
with, but
you
Again,
couldn't,
I'm not targeting one property.
Yeah.
It's a general policy.
No, what I'm just saying is, if you're putting on that floor ground level, is there another floor that's ground level the rest of the house? So it's one line. Is it?
yeah, all that's depending on what they're
So that,
proposed.
so if the addition gets flooded, so's the house.
So the house.
What we're talking about is you do not have to increase your elevation, correct?
Correct.
That's what we're talking
Now, here's the other thing, to say that we couldn't raise the road, that's completely false, because let's go back to the sewer thing. If I put sewer, we put sewer to this whole town, you're gonna have to connect because we put sewer in. So if I built a road higher and you have a property lower, you're gonna have to somehow adjust your property so it doesn't get flooded. It's not the town's responsibility to do that.
We have put a pumping station in it.
Which whatever. But so,
That's a whole nother conversation.
Yeah.
And people don't realize the extent of that conversation.
so anyway,
Mayor, can I-
can we have
can
some
I
public
make just a
comment, please?
couple of
Wait, 1 second, let's do
clarifications?
public comment and we'll bring it back to the commission. All right, Terry, you're up.
Well, actually, it's a question for you or the attorney, because too many people are talking about this thing. I understood that the new elevation for new construction was 9.5 feet. Is that not true? Is that the level? You're talking about this elevation, but you don't mention the number.
Well, you would have.
9.5 feet is what I thought that you had passed an ordinance.
Yeah, we're not talking about though.
On
elevation.
vacant lots.
No, I have a house and I'm renovating, I'm building a room onto it. So
Okay,
elevation is where it is.
Yeah.
Say like me and you put a renovation, something on our house. Like my elevation is, I think, 6.5. I mean, it's small. So I'm building to that elevation.
Right.
Mr. Mayor,
I know when
if I may just clarify one thing. My understanding is the two properties that we're talking about, they've hit the 50% threshold. And what that triggers is now you have to bring your entire property up to the current standards, which before the preemption, that would mean they'd have to elevate. I don't know what the exact elevation is, but they would have to elevate their entire house. That is whether you're building above the 50% or whether you're replacing building new. So the impact of the preemption is that right now in the town of Ocean Ridge, nobody has to build to the preliminary maps. Whether it's an addition that triggers the 50% or whether it's a whole new replacement.
I thought that was the reason why we went to 9.5, is that it wouldn't matter what the flood maps came back at, they'd be safe.
Wait, but that's what the state mandated, we could not do that.
And
We can't
actually,
create
that's
that
for
law.
new construction, not additions.
So that is
New-
new construction.
New construction has to
New
be,
houses.
I mean, where we are, if you go up the hill onto the ridge, you're above 9.5.
you didn't even need flood insurance.
Yeah. That's why you don't need it.
Yeah.
So I was a little bit confused. You're talking about a house that's rehabbed or adding onto.
Exactly.
Okay, when they added on to our house, they had to elevate that one section 1 foot different because the code went from 7 feet to 8 feet in those days. That's a long time ago. But I wanted to clear up on the 9.5 elevation for new construction. As long as you're below that elevation, you have to come to that elevation now with the floor level?
New home.
Yes.
New home.
Is that right? Is everybody saying
No,
that?
that's right, you have to, the new home, when you
I'm
build
not
a
agreeing
home.
to the 9.5. You
I think it's either
remember,
9 or
it's
10.
the crown of the road. It's called the NVA.
Yeah,
or
but
NAB.
that doesn't count anymore, the crown of the road.
No, that's the FEMA thing is based upon that.
Well, I thought it was sea level.
The base
I
flood
think it's
elevation.
Base
7.5
flood
plus
elevation.
crown.
It's
So-
sea level. Anyway, thank you.
So Christie, what are you
Well, you have another
advocating?
public comment.
Okay.
So
Victor Martel, 46 Harbor Drive South. Why in the world, as you said, Jeff, we would make a policy that FEMA hasn't even passed yet, that would create a hardship for a few of our neighbors? It smacks of this big brother, like, I know better than you, which is the previous commission, if you excuse me, seemed to think that they knew better than everybody else and forcing these people. And we're creating, basically at this point, 2 properties. We're creating a hardship on something that the state hasn't even decided yet. And like Carolyn said, they've been talking about this since 2019. Who says it's gonna be in 3 months? I mean, if you think the government moves in 3 months, then I got a bridge to sell you. That's absolutely ridiculous. So my personal opinion is until the state says something, why would we do it? I don't, I'm not a lawyer, and the liability issues are, I don't even see them there, but that's a whole other topic. But thank you.
Thank you.
It's actually it's a federal map, and the state has already made a decision.
Let's, hold up. Let's make sure we have any other public comment.
This is more, Dave Hutchins, 33 Harbor Drive North. This is more of a question than a comment, but it has been my understanding when the value of the remodeling, whatever you want to call it, exceeds 50% of the appraised value of the home, something like that, then it now has to comply with the existing code and would require that the elevation has to change accordingly. I think in the past, the way people have gotten around that is not be quite so grandiose the first time around. They build something, it looks good, they haven't exceeded the amount, and then they can come back after a certain amount of time.
5 years.
5 years.
Yeah, but the state squashed that.
The state squashed that?
That's what
Well,
they
thank
did
you
in
for that.
21, yeah.
That's
But
right.
I think the 50% factor is bearing on the town.
Correct.
And anybody's building, so.
Can we discuss that after we have the vote? I want to make a comment on what Dave said.
Okay, any other public, thank you, Dave.
Can I make one clarification?
Just let me close public comment. Let's stay in order. Any other public comment? All right, back to the commission. Lynn?
Thank you, Mr. Mayor. The maps from 2019 have been adopted by the federal government. They were adopted in early 2023. Because there are areas of Florida that have chosen to appeal the map, which is what Palm Beach County has done, which is what the county is saying, they anticipate a resolution to their appeal in January of 2024. That map has not gone into effect in Florida. That does not mean that those new FEMA maps have not gone into effect elsewhere in the United States. So it's not that it's taken 4 years and the government's going to take another several years. The public comment period in 2019 was put on hold. It was reactivated in 2022. Public comment was completed and FEMA did its due diligence and enacted the maps that were proposed in 2019 in early 2023. This was brought forward, and I know that Commissioner Cassidy does not understand or does not agree with my concern. But my role as the manager is to protect this community. And as a risk management, once I got the hold harmless and the letter and I was reading through it, I realized that there was no action if a property owner chose not to sign either one, which is why I felt this was an item that needed to come before the commission for discussion. This was not something that I, as the manager, could make a decision on because this was setting policy. You are deciding this evening how you want us to move forward until these maps are adopted in Palm Beach County.
Yeah, well, that's right for us to be making that policy decision.
We live in.
I mean, that's I understand the contrarian view to this is that it does have an impact on whether it be roads and flooding and all that other stuff that we're all concerned about. But the issue that we have at hand, there's twofold. One, and I brought this up before, is I think we need to re-examine that 50% rule, because it's been a hardship, and we have interpreted that worse than some other communities in Palm Beach County, and in the area. So we need to look at that and of how they've gone about in the past here, how they've interpreted it, and really what is a good way of, or what's the norm, because FEMA leaves a lot of wiggle room to the local community to interpret that requirement. And if you look at what it is, there's exceptions that's how somehow we don't recognize the exceptions that they have. So it's really odd. So I think we need to re-examine that, and I think it was supposed to go before P&Z. I brought that up before.
Yes, you did.
But with respect to this, I think we have no idea when the finality of that's going to be. It might be, I agree with Commissioner Cassidy, it might be in January, it might be later. As long as people go in with their eyes open, we can't prevent somebody from getting a permit unless we do the moratorium. And we're opening up a different can of worms. So I think the notice is good. And it's part of the permit process. What's, and I'm trying to think of the downside. What's the downside?
Yeah, it's good.
Okay, so you want to talk about the 50%? Because right now before you do.
Right, I want to do the vote because then I want to comment to David on the larger issue that he's just brought up.
All right, so I guess we'll take a vote on doing nothing?
No.
Or doing?
That we do this.
I make a motion that we do a letter of notice that is part of the permit application in substance to the letter that was done. I think I would prefer the town, I know this is not part of the motion. I would prefer the town attorney to go back, look at that letter again and make sure that it's covered, that those contingencies are covered or whatever needs to be covered. So in substance, in substantial format to what's been presented to us.
Does this letter of notice need to be attached to the property?
Well, no, it'll be attached to the permit.
It's the permit process.
So basically, anybody who comes in and gets a permit for building or renovating the house, that's right now over the 50%, would get that letter of acknowledgement in their permit package.
So here's the thing, and if there was get a second, I made the motion.
You made the motion, is there a second?
Second.
We can have discussion.
All right, any
Well,
more?
I would like to talk about that issue though. Why couldn't we put it on the title? Because the next person buying that place knows that there's a FEMA map working out throughout this country, and for whatever reason, Palm Beach County didn't like it. And the next person that buys the house, he gets flooded, then what happens?
Well, because we were gonna have the hold harmless attached to the deed, but now we moved to notice.
Well, because Ken introduced.
Right, no, I love the idea.
Yeah.
But why wouldn't we have the notice?
Well, I think what we talked about was that there would be the letter that would be acknowledged and it would stay with the permit for the renovation. If we did the hold harmless would be recorded in official records so that it would be, an official record. Then when did a title search, they would come across that.
So when you title search the notice now, that's gonna be part of the permit process. It will be available if somebody does a deep dig, but it's not normally looked at.
Right, if they do a deep dig to the town and come in and look at the permit file for the property, they'll see that there was an acknowledgement done. You could record it in official records, but.
So what would be our liability, not to owner one that's selling, but owner two that buys it and finds this out afterwards?
Well, I think, it's one of those law school exam things, but for the most part, for the town, we're gonna have sovereign immunity because we've got a state law that ties our hands that says
Understand, yep,
they can build to the prior standard.
I'm set.
All right.
Without giving legal advice, whoever's selling that property, if they don't
Disclose it?
it's an issue.
But you don't have to fill out a notice.
All right, is there any public comment on this motion? All right, back to the commission. All those in favor signify by saying aye.
Aye.
No.
Opposed? We have one no.
So now I want to address.
So adjust to 50%.
And Lynn, this P and Z commission meeting is so far long overdue, I can't believe it. And top of the list is this 50% rule that we created out of, the way it works is it's a 50% FEMA, but how you define the 50% is up to each individual municipality. And we, P and Z, took a very aggressive approach to what's 50%. So we need to have this joint meeting to discuss that, discuss flat roofs. Right now, you can have a roof that's a 4-inch pitch, but you can't have a 3, 2, 1, but you can have a flat. So it's, we have these issues that we need this joint workshop. And I just don't understand why we can't get it together. And if it's not attended by everyone, that's okay. As long as it's 3 from P and Z and 3 from the commission.
Yeah, I thought we would do that after we do the appointments, and we could do it sometime in January or December.
The roof pitch was actually discussed by P and Z at their last meeting, and I believe Christie is drafting a preliminary document on that for P and Z, or Corey did.
Corey has drafted a draft ordinance to take back to P and Z at their next meeting, which I believe will be their December meeting, to allow for a pitch of less than whatever.
412.
And to get rid of the parapets on the flats.
Right, to allow it, yeah. So that is moving forward through the P and Z process. And obviously, once they make a recommendation, it'll come here for your review.
I wonder if they're talking about roofing material, because certain roofing materials you wouldn't want to use on less than a 4 and 12 pitch.
We haven't gotten to that.
That's up to the owner.
Level of detail.
If the owner wants to have a leaky roof, that's his choice.
All right, so also we'll discuss that joint meeting. I think that sometime in January would probably be the best time.
Okay. And by the way, you don't need to have a joint meeting to go over some of this stuff. Great, have a joint meeting. But really, put it on the agenda for P and Z if the 50% issue, and get 5 of the local communities just as to see what they do and how they do it, and discuss it and make a decision.
But there's also a lot of other stuff that, permitting processes and other items that planning and zoning we need to go over.
I understand, but there's low-lying fruit that the P and Z can handle well on their own to give a recommendation to the commission so the commission can act. I mean, this is, there's no reason to reinvent the wheel in a lot of these instances. Any type of joint meeting should be on a very broader base and not a specific base. Because then we're just telling them what to do.
Yes.
Why do we need to have a P and Z?
Exactly. Because otherwise it comes up and then we have this ongoing mess that we find ourselves in.
Okay. I think we've got that pretty well settled for the next meeting. All right.
Somebody else will be doing it.
Yeah, they say, you're scot-free. All right, discuss related to participating in the public accessible website for advertisement and public notices with Palm Beach County. Lynn?
Okay, the Florida legislature adopted new regulations allowing public entities to partner with their local county and provide all public notices through a publicly accessible website. Palm Beach County has contracted with Civic Ready to provide the county's accessible website, which allows communities to then subcontract and develop our own public notices website. The cost to participate is $2,000 for each entity to participate in the development, and then an annual fee based on population, which for Ocean Ridge would be $5,000. The development and use of the website would potentially replace the town's current public notice publication, location, and costs, which currently all public notices are published in the Palm Beach Post. This includes notices for ordinances, the budget, planning and zoning board, the board of adjustment, and all other necessary notices. Unfortunately, printed press is a dying art form in today's society. Most people get their news electronically, whether it be through newsletters or websites or podcasts on the radio. And as we've heard, in 2020, there was some issues with the ability for people to have access to those public notices. By placing all the notices on a public notice website that would cover any and all participating entities in the county, we would have to maintain a mailing list, an email list every year, and we would have to do one other public notice every year, I believe in the paper, to inform everyone that we're using the public notices website. But in terms of
That's good.
cost,
So we still gotta use the paper.
Once a
Once?
year.
And how much do you think
We're
they're gonna
not
charge us
using
for
the
that?
newspaper. I love
How much are you gonna
it.
charge us? Yeah.
How much do we
We gotta
spend
go
on
to
the paper
newspaper, so we
now?
don't
right now, comparatively, it would be a wash.
Right.
Every year to publish the notices for the budget, it is somewhere between $2,100 and this year it was almost $2,400 just for the two notices we had to publish for the budget. That doesn't include any of the ordinance publications. That
Well,
we've
you already
done
answered
this
that
year.
question. It's $5,000 Palm Beach Post, give or take a few. It's $5,000 a year to use the electronic method. The only thing we're gonna be out is the startup of 2,000.
2,500.
Right.
Yeah.
So,
Okay.
an example, what we just discussed, if we were making a notice that we're having a special meeting on Thursday, could we now use this website?
Yes.
And that would work legally, Christie?
Yes.
Good,
I mean,
that's
That
great.
would be how you do your notices.
Oops. Pretty much everything's going.
It's a lot
Yeah.
for us.
You gonna make a motion for this?
Well, you get a public comment.
I get public comment. That's a good motion. Second.
So,
public
wait,
comment.
just so you understand, it's easier said than done, my friend. Because and I'm all in favor of this website. I'm not saying I'm not. But keep in mind, we have to draft it. So we have to
Yep,
have staff.
that's what Kelly does.
Yeah, so she's gonna drop what
She's
she's
gonna draft it for the Palm Beach Post letter, or she
Oh, yeah?
drafts it for the website. It doesn't matter.
Isn't there something a little different? Why don't you explain the process that you explained to me
I
before?
had my little training on Friday, so it did clear up.
It's a little
bit
better?
more. Yes.
Okay,
I
so you're
was
not
against it at first,
not as
and now I'm
distraught
all
as
for
you
it.
were?
Um,
Okay.
Basically, the state has accepted with their bill that what we submit on there is acceptable.
Great.
So the good thing is because we have Municode and now I'm getting my new agenda software, all these tie in together. So when I put a notice up on the website, whoever is signed up to get notices of this database will get that
You
notification.
mean who's ever signed up on Pacific Ray?
Yes.
Great.
Yes, we'll get this notice and I can link it to, like, say there's an ordinance change. I can link that ordinance where it currently is to what we are proposing and they can see what's changing. So they'll be able to see it. So you can do all different kinds of things with it. And it's acceptable.
That's great.
The state has accepted all the formatting that we
Fantastic.
have.
I think we ought to do that. I mean, what's the harm? I mean,
Right.
with $2,000 started, see where it takes us and then go from there.
So I'll
Is
make
that
a
your
motion
motion?
that we participate in the public accessible website for advertising and public notices with Palm Beach County.
Is there a
Second.
Second, public comment.
So Terry Brown, Howard Drive South. So how it would work is that you wanted to find a public notice in the town of Ocean Ridge. You would go to this website and click on Ocean Ridge and look at all the public notices that are there.
Correct, there'll be a
So
link
that-
from
so
our
that the
website.
citizen having their coffee in the morning, reading the paper, some people still do, you see the notices. And you say, oh, that's interesting, that's up in Jupiter, or that's Palm Beach Gardens. So you see all the notices that people choose to put in, or are required to put in the paper. Because that's the organ for public notices now. So this way, the citizen has to sit down at a computer and decide to search all over where the public notices are.
No, they're all
No,
housed in
no.
one website.
It's on one
Ocean
website.
Ridge,
You click on
Jupiter.
I
the
don't
town.
ask you to respond.
Yeah.
Okay?
Don't point
Under
at me,
public
Terry.
comment, don't you respond to
Yeah,
me.
then,
The mayor runs the meeting.
You can
not
put your
you.
finger down right now, Terry. We're gonna
Not
ask you to
Not
leave.
you,
all right, guys.
all right? You do it all the time, you're very negative.
You talk in the front row all the
Yeah.
time and disrupt us.
See?
Don't,
Carolyn, please. All right, sir,
So my
finish.
concern is that people are gonna have to realize that they have to search the internet for these notices.
Well, eventually it's gonna happen is that most of these municipalities are gonna go, this gets a county.
Yeah, I know the county's doing it, and a lot of people are doing it, but,
Can you clarify for Terry what the website looks like? You don't have to search the whole internet. You
No,
search
no, no,
on
no,
one
no, he's
page.
not talking about that. What he's talking about, say that you're looking through the paper, you can look at, oh, City of Riviera Beach is, raising their tax rate by X amount of dollars. If I don't go to City of Riviera Beach's website to check that, I wouldn't know that.
I
That's
haven't
what he's
checked
saying.
all the
Now what he does in the
municipalities.
paper, he looks and sees them like here, 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 here.
you'd have to look at all the municipalities.
Yeah, it's just a
find out what
convenience
the public
factor for
notices
Mr.
are.
Terry Brown.
Yeah.
That's what it is.
It's like that.
Stella?
Yeah, I'm just
trying to wrap my head around this, that since we have the Civic Ready and all our notices, why did we need to do this? And now I understand that because we had it published in the paper, so now we're gonna go with Palm Beach County, like the tax website or something?
No.
Like it would go on,
Palm
something
Beach
like that?
Go ahead,
County,
Glenn.
Palm
We're
Beach
not going to
County.
paper,
is-
right?
No, Palm Beach
Okay.
County is creating a separate legal notices website. Can you pull up the Broward County site?
Yeah.
Currently Broward
I'm sorry, I'm
County,
just trying to
no, that's
understand
okay.
this.
Currently Broward County already has theirs operational. I believe it's Broward County Legal Notices. And when you pull it up, there is, a block for each of the participating entities. And you click on the entity you want, and it pulls up all the notices that are currently active. Anything that's older that's,
Okay, I
is
get it.
archived. It will be linked directly from the Town of Ocean Ridge's website.
Right.
So you don't have to search the entire internet to
I
find
get
it.
that, just like realtors.com, if you want to
Right,
know what's
so
going on.
This is the
Good.
Broward, you can see it
Rich.
says Broward County Legal Notices.com. Right now, they have got 6 entities that have signed up and are participating. If you click on Parkland, you'll be able to see they have everything from bid notices out here, they got ordinance zone notifications, they posted their budget notifications there in August.
So basically,
Will this
you go to
eventually-
one spot
Right.
and look at all the notices.
I get it. Eventually, will this save us money from doing
It's,
No.
stuff?
no, it's
Yes,
basically the same amount.
Yes, ultimately, because it saves staff time.
That's a good point.
Well, you gotta do the same amount of typing, right?
You do the same amount of typing, but you don't have to do the coordination with
wash,
the
except for the
press.
2000.
You-
All right, thank you for explaining.
You're welcome.
Well, I think in the future, though, papers are gonna be more expensive to advertise, where the internet's probably gonna be cheaper, about the
Well, how
same.
far in the future, we'll never get the paper. I barely get it. The guy never shows up till 10 o'clock in the morning.
But you get the bill.
Any other public comment? All right, back to the commission. All those in favor of this ordinance, say aye.
Aye.
Motion carries.
I don't think it's an ordinance, is it?
Or not ordinance, I'm sorry.
The expenditure.
I'm getting my town manager report.
Yes, okay, so October flew by and we've had some transitions. Rob Blanchett with the building department has stepped away to go full-time position with another community. We hated to see him go, but we didn't want to hold him back. We have 2 new officers in the police department. Jonathan Russell Lynch, he goes by Russell, has started, I believe, 2 weeks ago. We have a new officer starting, is it next week, Scott?
Next Monday.
Next Monday. So that'll be our last position in the police department that's filled. We had our new dispatcher that just started this evening or today, and we have another dispatcher that is going through the background check, so we hope to have all of those positions filled. We thought we were going to bring Liz Mora back, but she's not going to be able to join us. We are bringing in a different clerk in 2 weeks for the building department. October was a big month for us. The town clerk hosted the Clerks Association monthly meeting, and our town clerk was sworn in as president of the Palm Beach County Clerks Association. And we also hosted the Palm Beach County City County Managers monthly meeting and had an opportunity to show off our community. We completed our NPDES audit and site visits, and they were very impressed, and they really liked the retention pond at A1A. We got all kinds of kudos for what we've done there. Sea turtle season has come to a close, and hopefully, knock on wood, we will make it through November and get through hurricane season unscathed again. And this November, we want to acknowledge the anniversary of Sergeant Gary Roy, who's been with Ocean Ridge for 12 months, or 12 years, not 12 months. And we are celebrating birthdays of Billy Armstrong and also Officer Alex Sasov. The commission is aware, and I want to make the public aware, I will be out of the office beginning November 9th through November 17th for a surgery. I will be checking my email during that time. Trying to stay up on voicemails, but if you need me, please try to send me an email. for several days, I will have limited ability to respond to phone calls and texts. If it is something that is time sensitive, please reach out to the town clerk and she will be able to reach me, or continue to try and reach me until I am available. I believe that is all that I have this evening.
Thank you. Any questions?
Nope.
Christie?
No report?
Yay.
Chief?
My report's in your packet. If you have any questions, I'll be happy to answer them. As a town manager, so I'll introduce in December 2 new employees. We'll have a new officer and another dispatcher. It will be full. And I'd like to thank Stella. She delivered the flag. I put it up. Very nice donation. Thank you.
Thank you, Chief.
I have a question.
Yes.
On the citations, the night citations, do you know why, like Sergeant Roy compared to Sergeant Stang, he's like 7 times as many citations, 8 times as many written warnings,
It
and
depends
5
on the
times?
activity of the officers on that shift. The sergeants are addressing activity lows right now with certain shifts, so it just depends on.
But they're both on the night shifts.
Right,
They're
it
both-
depends on
The day?
the proactivity of the officers that are working.
There's one right now. Just went by.
You see the lights?
Yeah.
He must have heard me. That's Roy going after him. Get his numbers up.
Anything else?
Good question.
All right, thank you, Chief. All right. Discuss regarding staging for construction parking for properties on narrow and/or one-way streets. Commissioner Katz.
I just was bringing this up in response to the most recent planning and zoning meeting when there were quite a few residents from Ocean View there, and they were very concerned about a new home that's going to be built at 32 Ocean View. And the roads are very narrow, one way, and the staging of construction vehicles and whatnot. So I brought it up and talked to Lynn about it. I know with 6273 that they were parking North Ocean Pyramid House here. They were parking a lot of vehicles, I think, at the beach or at Town Hall, and then they would bring the workers back and forth.
They also had a lot of space on that property.
Yeah, they actually are staging and have an agreement with Boynton Beach to park their workers' vehicles at the park.
They will. Okay.
No, that's with 6273.
Oh, right, okay. But I'm saying with 32 Ocean View.
Yeah. The challenges with staging at Town Hall is we don't know what kind of equipment or vehicles they're going to be parking here. Also, we've got to have parking available for town activities, town business, whether it be people coming in and out of the building department for different meetings that, the community center is reserved for. As well as, just potential security. We would then have, unknown vehicles parking here. We generally, we prohibit parking for the beach, and by having vehicles that are not employee and town vehicles parked in the parking lots, it's going to make it much more difficult for the PD to control that parking of individuals that are going to the park and just going to the beach.
Plus,
All
you
right,
get
so-
the wrath of Betty if you took up any more parking.
Yeah, we really, so on a serious note, Ocean View does have very narrow streets.
Yeah.
Right? So, because it really comes down to you, Chief, because if I'm having a heart attack and I live right up the street, there's no way the ambulance is going down that street if there's 15 vehicles parked on that street. So how are you going to, in those little streets, be able to make sure that the parking there, the construction parking doesn't get out of control?
I mean, the rule is the vehicle has to be off the street where a fire truck can fit. I think that would, even if you allow two spots per construction site and they can park in, they would have to have clearance.
So can I make a suggestion? On any construction there on those streets that are small, the town manager and the building official should meet with the folks that are doing this and explain to them the rules of which it's going to take in order to be able to park there. They're going to have to stage. Unfortunately, the homeowner will end up probably carrying the brunt of that cost when they build a home, but they're going to have to do that because there's no way you can park 10 cars, especially at the very end of the job where you've got stucco guys and painters and everybody else.
So,
I think currently we only allow 2 cars.
well, 2 cars, but then you can park on the site, but the problem is you're not gonna be able to park on the site.
It's
You're gonna
not
have to
enough parking.
stage. In fact, at the 6273, I was always that guy that, he always parked over there in the.
On Hudson.
On Hudson or not, he actually parked across the bridge because you walk across the bridge. But anyway, they're gonna have to stage the vehicles, you're gonna have, really, you should meet with them
So,
on these particular properties and these particular construction sites to like basically explain to them, hey, these are the rules. And we also may want to look into some kind of, at the planning and zoning of right-of-way permits. So that we actually, the people, they have to be able to, if they're gonna park on the road, there's only so many vehicles, and if they want more, they have to get a permit for that.
we discussed that a couple of years back, I think, before you rejoined. And the problem was that the subcontractors had different people coming in, so they lose track of
That
that.
doesn't make any difference, because what happens is the contractor on the job is control of those subcontractors, period, end of
But we were
story.
talking about giving them actual cards that they were allowed to park there, but that's where it got confusing.
We actually do currently.
All right.
You do give them
Like,
cards.
we do have 2 right-of-way permits that we allow for the building permit.
So I have an idea for, I don't know who's building on Ocean View, but Briny Breezes rents their parking lot, which is west of A1A, that great big plot of grass.
Oh.
They can, so the builder, the homeowner, whoever, should go down there and, pay them a fee and park.
Good point. All right. So you got that info, Lynn?
Yep.
All right, is that it, Carol?
Yep.
Steve?
Thank you.
So the reason why I wanted this discussion is one commissioner cannot, tell the town manager to do something, so I need a consensus here from the commission. Very simple. Years ago, Phil will remember this, we explored how to stop the Woolbright Bridge from opening so frequently in season. And it turned out we couldn't. We tried to switch it to on the 15 minutes, we tried this, we tried that. There's policies in place at the state level that don't allow us to change that from an on-demand to a timed opening. But my question that I want Lynn to explore with, I don't know if it's the Army Corps of Engineers or the county actually owns that stretch there. It's County Bridge. The thing that's really annoying me now, I happen to live right at the foot of that bridge. If I go over the bridge.
Really?
And that's why I bring it up?
I go over the bridge to go to the Wells Fargo Bank. I
Yeah.
go into the bank and the bridge is up, so I have to wait to get there. I come out of the ATM, like a 5-minute thing. I'm going back and now the bridge is going up again. So if there's a way we can tell this bridge opener, the rule is you cannot open it more than once every 15 minutes. It is on demand, but if the boats have to wait, 7 to 8 minutes, it would be very beneficial. Lynn, I don't know if you noticed last year, south on A1A by the yacht club in Colonial Ridge, you would have like 3/4, especially when Gulfstream School gets out, you got 3/4 of a mile of cars there. And if anybody trying to exit Ocean Ridge Yacht Club, Crown Colony, Colonial Ridge, can't do it. It's all backed up.
Yes, I was aware of that.
So if we can get them to agree to tell the bridge keeper, don't open it unless there's a 15-minute time lapse.
And there's no way to put it on a 30-minute like
No,
the other
can't.
bridge?
We tried, Phil tried, we tried it in no way, we tried a lot of stuff.
Because of the height of the bridge.
No, it's because of the distance to the Atlantic Avenue. There's rules in place about how long
That's
you can take
true.
the boat
Yeah.
to get places.
Or just make sure when it's windy out and all the boats have to go in the intercoastal, don't go to the bank.
Yeah.
There
you go.
There you go. All right, Lynn, you got all that?
Yep.
All right, thank you.
With the consensus to have Lynn do that?
Yes, absolutely. Any other issues, concerns? Well, thank you everyone for coming tonight. We really appreciate it. See you next month.
Yeah.
Meeting adjourned.
We tried that.